I want to know, can we conclude that the situation in Hungary in 1848 positively impacted Croatian independence because it weakens Croatian connection with Hungary and strengthened the position of Ban Jelačić?
Practically, that would be the consequences. These were not intentional consequences, we'd say, from the Hungarian side, but in the end, this was the end result that practically with the breakup of the revolution and the introduction of the absolutism, in the end, we can see that there was created this Croatian legal autonomy that was much. It can be interpreted whether it was fortified or stronger or less strong than it was before, especially when we take into the account the later settlement. But concerning the specific legal system, we could say that the results were, as a reaction, the stronger position of the Croatia within this Hungarian part, or as we call usually the lands of the crown of St. Stephen, formally. So the answer would be a positive on your question.
Thank you. Another question to Professor Karlovic. I think you are familiar with the fact that Ban Jelačić is not a positive figure in the Hungarian historical memories.
Yeah.
So my question is, Professor Cepulo once told me that you Croats felt in 1848 that your rights, your autonomy was infringed by the Hungarians in Pressburg, so by the April laws. And you were now using the expression safeguarding the Croatian statehood or the
Croatian historical state rights.
Historical state rights. What did we make wrong? So what was the mistake we made?
Yeah. Well, I think Professor Cepulo.
We had to suffer the first attack right from Croatia.
No, certainly Professor Cepulo would be a person who would be much more qualified to answer your question, but in general would be that from the Croatian side it was felt that the autonomy, or practically that the autonomous position of Croatia was not recognized within these new articles. Practically that there was this unitaristic or centralized concept of Hungary that was introduced, practically that all parts of the Hungary, of the lands of the kings of the crown of St. Stephen, that they are all equal, that there are no special rights of the Croatia or the Croatian parliament or Croatian Sabor, and in that element it was felt that the autonomous rights of Croatia were infringed, as a continuation also concerning the introduction of Hungarian language, practically one issue that lasted then for a longer time. So this would be this right or this jura municipalia that were infringed, and practically in 1848 it was changed practically with the abolishment of the feudal system, because jura municipalia were considered as an element of this feudal right, or practically because the parliament, because the Sabor was feudal parliament, feudal diet, practically they were changed to historical Croatian state rights. So the terminology changed as well after the revolution. So I hope.
I have one remark to Professor Columbert and one question to him. The first is a remark to the draft of the Reichstag at Gromasic and the fundamental rights. This was a quite modern conception of fundamental rights. For example, this draft proclaimed the cancellation of the privileges of the aristocrats, and he provided the introduction of civil marriage, and these are things which were coming out in Austria in 1919 and 1938. So this was a very, very modern concept of fundamental rights. And the second remark, and combined with the question, is the idea of a Bohemian Charter, böhmische Chart of the year 1848, it was derived from a permission to the Czech majority of the Bohemian Diet in the very beginning of April 1848, which promised a special provincial constitution for the Bohemian province. And this idea, I think, was present until the end of the monarchy. So I wonder that you said that the December laws were serving as an example for the constitution of Czechoslovakian Republic in 1920. So what is your meaning?
As was mentioned in the presentation of Professor Karlovic, we also had something as the Czech historical right or this concept. So yes, generally the Czech point of view was the fact that we had rights and privileges, but sincerely, and that was right from the German politicians during the time, that Czechs forgot the fact that they lost many of them. So yes, there are many proposals. You mentioned the decision of Diet, I mentioned the Moravian constitution, but still, unfortunately, it is not, from my point of view, the matter of law or legal history, but it is the matter of the nationalism and the conflict between Czechs and Germans, which were still present, but we can say before 1918, the establishment of the Czechoslovak state. Before that year, there was the idea that the Germans or Austrians are the punishers, and they destroyed the Czech wonderful future. And then in 1918 there was the change, and Czechoslovak behaved in the same way against German. That's the same. But as you said, from Czech politicians, thanks to the nationalism point of view, it was much more important to pinpoint and pick some sources from history which were in favor of the Czech historical right. But as was mentioned during the 1870s, that's just or Czech politicians forgot that it is not so easy, because there were impact during the reign of Maria Theresia and Josephine reforms, which influenced the statehood of Czech lands. So I hope I answered. Yeah, thanks a lot.
Question for Professor Gedikli. And if I understood you well, you were speaking about the prohibition of slavery, and that it was enacted at once, but there were later on still some cases concerning the slavery. And I wanted to ask, concerning the size of the Ottoman Empire during the 19th century, so can you trace these cases or these issues? So was there a larger difference, for example, between Arabia and the enactment or the enforcement of these laws, or the areas of Palestine or Syria or Turkey now proper? Can we see differences in the enforcement of these laws? Maybe can you just elaborate? Thank you.
I think there is different situations. There is a huge, geography, and legally slavery is forbidden, but in the practice, customs and old practices go on. But sometimes slave, how do you say, when he or she said that I am a free man, the constitution and the Ferman forbidden the slavery. You cannot do something for me. I am a free man. Yeah, actually, there are differences between the countries, or between the Palestinian or Anatolia and Arab villages.
Yeah, that was the question. So, can you follow the abolition of slavery in practice where it was early, where it was kept for longest.
Yes, yes. Yeah. Legally it's forbidden, but the practice for some time goes to life.
Thank you. I also ask Professor Gedichli. Thank you for the presentation. And if I was correct, you mentioned that the transforming legal system is with European models. I would like to ask you that during the 19th century in Turkey and Ottoman Empire, has any influence of the jurisdiction or the juridical system has any influence the French law or the French convention or the Code Napoleon or Code Procedure? Thank you.
Yes, thank you. At first, the Ottomans tried to get the Napoleon Code. There was a preparation for this, translated into Turkish, but would be two parties. One is pro-Napoleon Code, the other against it. The second side is successful. Was the leader of Ahmet Cevdet Pasha, an historian and statesman and lawyer. He succeeded to debance Ottoman civil code, the Islamic law, and in 1869 and 76, in 7 or 8 years, he and his colleagues made this Ottoman civil code. It happened about 16 sections, and how do you say? They did step by step, section by section. Otherwise, would be unsuccessful. But there are, this is the Ottoman Civil Code, and 50 years practiced in Turkey. In 1926, prohibited, I mean, changed his, changed it from the Switzerland one. But land law also depends on the local customs, Sultan edicts. It is also enormous codification of Ottoman. Then Ottoman Civil Code Mecelle, and 19th century, in the 19th century, 1917, family code also promulgated in Turkey. It is also, it's a very revolutionary code for the Islamic legislation, because the code changed many, how do you say, common opinions. In Islamic law has many schools. During the Mecelle, Ottomans depends on the one school, called Hanefi school, but now in the family law, they collect all the proper opinions from other schools in the first time. So that's why it's very important legislation in the Islamic law. Thank you.
Thank you so much. And my question is...
Just one question. Actually, our reforms movement takes examples, took samples from the French practice. we don't get the Code Napoleon, but we get the commercial law, we get the commercial procedural law, we get the administration or organization of the judicial. For example, three-parted courts, first, second, and court of appeals, Conseil d'État, and the other things, all comes from the French examples.